So we need to talk about the critical assault weapon ban challenge that was set to be considered by the Supreme Court today, but has now been pushed out and rescheduled. Now, really quick before we jump into this video, I want to thank everybody for supporting this channel. Also, the Gundy's Awards are up again. I'm nominated in multiple categories. One of them is Influencer of the Year. And then also our podcast, The Liberty Lounge, is up for Podcast of the Year. So if you want to vote for me in the podcast, links will be down below. I appreciate your guys' support. And also don't forget to like and subscribe to this video. YouTube loves to unsubscribe people, so just double check that. As I mentioned in the intro, in this video, we need to talk about the very important assault weapon ban challenge that was up for Supreme Court consideration. It's currently pending in front of the Supreme Court, and it was set to have conference today, but the Supreme Court has taken action on this and has decided to reschedule the conference and consideration of this case. This preemptive rescheduling of this case is very interesting. It's a little bit different than what we traditionally see when it comes to the consideration and rescheduling of cases, and this could mean a few things that we need to talk about. The critical case we're going to be talking about is the Snope versus Brown case, and that is a challenge to the state of Maryland's ban on so-called assault weapons. This ban was challenged in a federal district court in Maryland. However, that case was then dismissed by the lower court because there was already a case on the books that already found that the state of Maryland's ban on so-called assault weapons did not violate the Second Amendment. It was then appealed for the first time to the Fourth Circuit, who also upheld dismissing this case. Then this case was sent to the Supreme Court for the first time back in 2022, seeking review and reversal of those decisions. The Supreme Court ultimately ruled in the landmark case Bruin in a 6-3 decision, and then after that, they decided to grant, vacate, and remand the Snope case back down to the Fourth Circuit for reconsideration in light of Bruin. This case was then opened back up in the Fourth Circuit in December of 2022. A 3-judge panel heard arguments on this case, but then this case sat dormant and no decision was issued for 13 months. Then suddenly the Fourth Circuit en banc panel decided they wanted to step in, and they took control of this case and took the case out of the hands of the 3-judge panel. The Fourth Circuit en banc panel issued a decision using the military use test, finding that these types of rifles and these types of firearms could be banned by a state like Maryland. And once again, the Fourth Circuit en banc panel protected this type of Second Amendment infringement. Now, there were some dissenting judges on the Fourth Circuit panel. Those judges were Richardson, Niemeyer, Agee, and Quattlebaum, but they were outvoted by their colleagues. So the Fourth Circuit en banc panel at large, through the majority, upheld this rifle ban. Now, that Fourth Circuit en banc panel decision was not shocking by any means. I think we all anticipated that that's what they were going to do, especially when they took control of this case once again. But one of the silver linings with that decision was the fact that it now teed up a final merits case, a final merits review on a rifle ban to now go once again up to the Supreme Court. Initially, the state of Maryland was trying to stall this case by asking for multiple extensions to respond to the petition. The Supreme Court recently only gave the state of Maryland a partial extension, and so they were due to file their response by mid-November, which they did. The state of Maryland argued that in accordance with Bruin's command, the Court of Appeals examined the relevant historical traditions and concluded that even if the weapons are protected under the text of the Second Amendment, Maryland's law is constitutional because it falls squarely within the strong tradition of regulating excessively dangerous weapons once it becomes clear that they are exacting an inordinate toll on public safety and societal well-being. So they're also kind of framing this as a public interest argument, which is similar in ways to the type of standard that was already rejected by the Supreme Court in Bruin. They then concluded their response by saying that the Supreme Court does not need to review this case right now because there's not yet a circuit split among the circuit courts on this issue of rifle and magazine bans and these types of issues about what is an arm. Now, that's funny because really the only circuit courts that have addressed this come out of liberal areas, states like California and the circuit courts like the Ninth Circuit, because why would you have someone like the Fifth Circuit reviewing this issue and causing a circuit split when the state of Texas doesn't have a statewide ban on rifles? So you're never going to really have a circuit split on this issue. The only way that would ever happen is if you had some random situation where maybe an outlier like the Fourth Circuit 3-judge panel would have issued a decision saying that these rifle bans are unconstitutional, but here the Fourth Circuit en banc panel prevented that from happening. Now, the plaintiffs responded to this by saying 30 years ago, the court described semi-automatic AR-15 rifles as civilian commonplace, generally available, and traditionally lawful firearms. 16 years ago, this court confirmed that the Second Amendment protects the right of individual citizens to possess firearms that are in common use for lawful purposes. In the intervening 16 years, semi-automatic rifles have continued to be commonly available. This, therefore, should be an easy case. Yet incredibly, in 16 years since Heller, every single court of appeals to consider the question has concluded that such bans are constitutional, employing a variety of tests that are uniform only in their failure to adhere to the principles established by this court. Maryland asked this court to deny certiorari to allow even more time for percolation, but enough is enough. The lower courts have proven themselves incapable of following Heller's clear guidance, and this court should intervene without delay. So this is at a very critical stage now. Now, like I mentioned, this case was set for conference and it was supposed to happen this Friday, but then we received an order from the Supreme Court essentially preemptively rescheduling this case. Now, why that's a little bit different is because usually what you'll see with a lot of these two-way cases and a lot of cases in general is you will have an initial conference set. It will maybe go to that conference. So it would have gone to conference on Friday. And then in the order list, if they were going to reschedule it, you would simply see nothing in the order list. And then you would get a notice on the docket that said, hey, it's been pushed and rescheduled for a future conference. And it's interesting here because the court has preemptively rescheduled this and they have not yet set a conference date for when that reschedule is going to happen. So that could signal a lot of things. I know a lot of people are speculating about what that means. It could mean good things. It could mean bad things. I know some may believe that simply because this is rescheduled, it inherently means something good. I think in some ways it means maybe something good. It means maybe the Supreme Court is taking a closer look at this, but it could also mean that the Supreme Court is simply trying to stall this case out, push it out even further, whether or not that's to push it further out for maybe another case like Duncan to make its way to the Supreme Court, or maybe push it out even further, which would be pretty radical, push it out for a really long time and maybe wait for some of the 7th Circuit Illinois PICA cases to make their way through the process and eventually make their way to the Supreme Court. I don't really think that's going to happen because that is a long game there. So you would have to have this case on almost a permanent hold for a long time, probably a year plus for those 7th Circuit cases to make their way through the process. Also keep in mind when it comes to the conference and reschedules, we've seen plenty of cases that have been conferenced and rescheduled multiple times, especially two-way cases, conferenced and rescheduled multiple times. And then ultimately, after 10 or 12 conferences, then suddenly denied review by the Supreme Court. One of the ones that automatically comes into my mind was one of the pre-bump stock cases, that came before Cargill. That one was rescheduled for conference and went to conference and rescheduled multiple times, 8+ times, probably even more than that. And then eventually, suddenly out of nowhere, the Supreme Court denied review to that case. So a reschedule does not inherently mean that the Supreme Court is going to grant review or really wants to take a case. It could simply mean that they're trying to buy more time. Maybe some of the justices want to get together and discuss the issue a little bit more. I do think it's interesting that you're seeing both the Snope case and the Ocean Tactical magazine ban case rescheduled multiple times. With the Ocean Tactical one, that deals specifically with magazines and a preliminary injunction. So it's interesting that that one was preemptively rescheduled and was set for conference today. And we thought that maybe they were going to consider that along with Snope, but then Snope was preemptively rescheduled also. So some very interesting things going on right now. Could simply be the Supreme Court maybe wanting to push this out until next year. We thought that maybe they wanted to address it before the end of this year, but maybe they're going to push it out into January. I do think that there is a strong appetite by some of the justices on the Supreme Court to want to finally address this arms ban issue, defining what exactly is an arm and what exactly a state can do as far as banning specific types of items like magazines and characteristics of firearms and things like that. I think it's clear that Alito and Thomas have been very interested in this topic. We've had multiple times statements from both Alito and Thomas about the Supreme Court needing to take action on these issues and being upset with lower court defiance of their decisions in Bruin and some of their other rulings. Now, there's always the most negative situation where this could have went to conference this week, and then suddenly we could have got a denial or review next week. So at least for now, this case stays alive. We're going to keep our eyes on the docket to see when exactly it's rescheduled for, or whether or not it's going to pretty much sit dormant for a while. And if this sits dormant for a while without any update of when they're going to reschedule the actual conference, well, then I think that would signal that maybe they're waiting for something else to work its way to the Supreme Court. And when we get more information, when more things kind of shake out on this, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.